Omolara Yakubu.
Yes, my lord.
Mustafa.
Especially, sir. Abiodun Alabi. Only allowed my class out with this one.
Judgment in the case of Olashade Abiodun and Suleiman Mode, not the lights, the HP. The petitioner presented a petition before this court on the 9th of October 2024 for dissolution of the marriage contracted with the respondent Suleiman Mode on the 18th of February 2022 as a federal marriage registry. They also on the ground that the marriage has fallen down in that since the marriage, the respondent has been such a way that the petitioner is not reasonably expected to live with the respondent, and the respondent has presented the petitioner for a continuous period of 1 year preceding the presentation of the petition. The original petition was filed on the 9th of October 2024. The respondent filed an answer to the petitioner for the petition on the 27th of November 2024 on pages 17 to 22 of the case file. The petitioner filed an amended petition dated on file 24th February 2025 with the leave of the court. The petitioner's final original address dated 12th of May 2025 is on pages 85 to 90 of the case file as the respondent post petitioner's final original address dated 16th of May 2025 is on pages 91 to 96 of the case file. The respondent denied all allegations in the petition and cross petition on the fact that on the ground that the petitioner has behaved in a way that the respondent is not reasonably expected to be with the petitioner and also cruelty. And also requested that the marriage digital particulars of the parties. The petitioner's given address is 2675 Providence Way, Sacramento, California, United States, whilst the respondent's stated addresses are 324 Abiodun Industrial Estate, Little Abiola Way, Kenya, and 30 Ogoyo Estate, Jeffrey Street, Lagos State, Nigeria. The first address is the office address. The petitioner was born on the 2nd of January 1994 and the respondent to 11th of July 1988. The petitioner is within the meaning of the Act domiciled in Nigeria. There is no child of the marriage and no property jointly owned or given by the parties. The petitioner pleaded circumstances leading to the breakdown of the marriage in paragraph 7, 8, 1, and 8 to 24 of the petition. The facts are reproduced in the body of the petition. The petitioner seeks dissolution of the marriage on the ground that the marriage has broken down irretrievably and also an order compelling and directing the respondent to return or release forthwith to the petitioner all original title documents of a piece and parcel of land measuring 3.5 acres, situated and lying at Bala of Edere Bala Road, behind Government Secondary School Bala in the Asha local government area of Kwara State, being landed property of the petitioner, which the respondent held the original title documents in trust for the petitioner, and others as the court may deem fit to be. The respondent cross petition also seeks dissolution on the ground that the marriage has broken down irretrievably. The respondent pleaded facts leading to the breakdown of the marriage in paragraph 6 of the cross petition, which has been reproduced in the body of the judgment. Yeah. Evidence of the petition. The petitioner gave evidence that she registered months with the United States Air Force. It stated that she resides at 2675 Dublin Way, Sacramento, California, United States of America. Parties got married on the 18th of February 2022 at the Federal Marriage Registry. She sent out the marriage certificate as XBPW1A She mentioned that her maiden name is Adishida and stated that she was never married before the current marriage. She testified that she was born in Ondo State, Abiodun, on the 2nd day of January 1994, and she flew to Nigeria after the marriage, and parties cohabited at 13 Julius Olusoya Street, Igogo, Bayeku, Ikorodu, Lagos State in 2020, and then moved to 30 Ogoyo, Estate, Lekki Phase 2, Lagos State to 2023 when cohabitation ceased. The petitioner stated that she met the respondent in 2018 when she traveled to Nigeria for the first time to meet her family. She stated that the respondent was told to pick her up at the airport and was introduced to her as her contracted cab driver. She stated that the respondent took her childhood friend's phone and started chatting with her. She further stated that she responded, well, thinking she was chatting with her childhood friend. The petitioner stated that the respondent later revealed his identity and parties became friends. She stated that she returned to the United States on the 30th of December 2018, but that communication continued between the parties. She stated that she wanted the respondent to come to the United States, but it did not work. The petitioner stated that she resolved his financial issues, gave him money to start a car business for the respondent to supply for personal purposes. The petitioner stated that after the parties got married, she saw a message on the respondent's phone from a lady, and when she confronted the respondent, he denied knowing the lady. The petitioner testified that when she got back to the United States, she reached out to the lady on Facebook, introducing herself as the respondent's wife. The caller stated that the lady took a screenshot of the messages and forwarded it to the respondent. The petitioner stated that the respondent started threatening her, even with a property document which was in his possession. The petitioner stated that the parties got separated for a while, but that the respondent kept on begging her and that the parties made up and got back together in August 2022. The petitioner stated that the respondent stated that he needed a new place, which she gave him money to move to Lekki. She stated that in April 2023, she came to Nigeria and got pregnant as planned and then returned to the United States in May 2023. The petitioner stated that the respondent was supporting the first trimester of the pregnancy, but that later the respondent insulted her, threatened her, and said he does not want the baby anymore and that he wants a divorce. The petitioner stated that the baby had a condition called Down syndrome and that she was advised to terminate the pregnancy. She stated that in September 2023, the baby was taken out at the hospital, but that the respondent was not caring during this period. The petitioner stated that in December 2023, the respondent told her that he does not love her anymore or efforts to resolve the issues, including counseling and talking to the respondent mom who abortive. The petitioner urged the court to grant her prayers as contained in the petition. On the cross-examination, the petitioner confirmed that she was born in Nigeria and was 8 years old when she left the country. She confirmed that she was chatting with the petitioner, thinking it was her child. She further confirmed that the petitioner told her he was the one chatting with her. The petitioner confirmed that Tosin is her in-law and childhood friend. She further confirmed that the family gave her his number to contact him. She stated that the respondent proposed to her and that the family did not like the respondent and that it was not her family that asked her to marry the respondent. The petitioner stated that she gave the respondent money at different times and that she cannot tell the exact amount of money. She further stated that she informed the respondent's mother of the issues between the parties, but that when his mother called to find out what was going on, the respondent gave excuses to his mother. She testified that the respondent later wanted her not to discuss such issues with his parents again. The petitioner stated that she never insulted the respondent's mother and further stated that the respondent was supposed to go for his interview scheduled for October 2024, but the parties had already parted with. The petitioner confirmed that she had a Facebook account, that she chatted with Sandra on her Facebook account. She confirmed that the evidence of the chat is with her lawyer and that parties had issues like every couple. The petitioner stated that she did not inform her family about the issues between the parties because her family did not approve of the marriage. The petitioner stated that she saw the chat with Sandra after parties got married. She further stated that she does not have the message and confirmed that the respondent denied knowing Ms. Sandra. The petitioner confirmed that she did not see any other message between the respondent and Ms. Sandra because she came back to the United States. The petitioner confirmed that the respondent did not send any documents to her and she knew he purchased the land. The petitioner stated that the respondent has all the physical copies of the land documents. The petitioner confirmed that she stayed for 1 month in Nigeria and got pregnant. She confirmed that the respondent was aggressive but did not beat her. She confirmed leaving Nigeria. She confirmed that the respondent told her he does not love her anymore in November, December of 2023. The petitioner confirmed that she's a citizen of the United States and Nigeria. Evidence of the respondent cross petitioner. The respondent cross petitioner gave evidence that he resides at 30 Ojodu Estate, Lekki, phase 2. The respondent stated that parties got married on the 18th of February 2023 at the Federal Marriage Registry, Lagos. The certified true copy of the marriage certificate tendered by the respondent was submitted as exhibit RW1E. The respondent stated that he is with the documents and that he is the one that purchased the property for the petitioner, which is 2.5 acres in total. The respondent stated that the first purchase was 1.5 acres and that the certificate of occupancy is out. He further stated that the other 1 acre is still processing in Kwara State and that the total number of plots is 20. The respondent stated that there was no prior demand for refund of this COO and that it was after the case was filed that the petitioner asked him to give it to someone he did not know. The respondent stated that he advised that it was better if the petitioner comes to reclaim the documents herself, that he cannot give the documents to unknown persons. The respondent stated that there was no compulsory conference between the parties, and the parties cohabited at 13 Julius Adesonga, Ojodu in 2020. And in 2022, they cohabited towards the end of 2022 at Lekki phase 2. The respondent stated that the petitioner no longer stayed with him and she came to Nigeria in 2023 and that she said she will end the marriage in 2024. The respondent stated that it is not true that it is a threat to the petitioner and that there were arguments between them at any time she visited. He stated that the petitioner got pregnant in 2023 and he was happy and the parties were into his parents. The respondent stated that he was virtually present with the petitioner throughout the pregnancy and that the parties had friends physically present with the petitioner to support her. The respondent stated that it is not true that he impersonated Tosi and that he met the petitioner in 2018. He further testified that he told the petitioner that it is not all issues between the parties that should be reported to the family. The respondent stated that he forgot to wake the petitioner up for work and she got mad. The respondent stated that he apologized but she called his mother to report him. The respondent stated that he told his mother not to come and that the matters can be resolved by the parties. The respondent stated that in 2019, the petitioner wanted to rent a car and that he suggested the car purchase was more economical and that she can give the car to her mother whenever she wants. He stated that the car had an accident, that the car got into an accident and that he sent a video recording to the petitioner. The respondent stated that the petitioner said whoever is at fault should fix the car. He stated that he fixed the car and that the car was sold as a scrap. The respondent stated that the sales receipt was presented to the petitioner. The respondent stated that the petitioner's behavior changed after the party started processing the visa for the respondent. He stated that the petitioner stated that if the paper process does not come through by 2024, she will end the marriage. The respondent urged the court to dissolve the marriage so that it can go in peace. Under cross-examination, the respondent confirmed that he had been working with trade depots since 2017. He confirmed driving professionally. He confirmed that he had asked the petitioner to buy a car. He stated that he's the one maintaining the vehicle and that when the petitioner is not around, the vehicle is parked. He confirmed that the vehicle was involved in an accident, but that it was the mechanic driving the vehicle at the time. The respondent stated that when she sold the vehicle, he did not return the cash received from the sale of $250 to the petitioner, but that he used it to process her visa on arrival in 2023. He confirmed that parties met in 2018 and he was not engaged at the time to drive her around. He confirmed that he met the petitioner at a family house in Akure. He stated that he was there to work for the petitioner's in-law, not the petitioner. It stated that the petitioner's in-law came in from Germany. The respondent stated that he knows Sandra Bishop Royal and they are Facebook friends. It stated that it is not true that he's having a relationship with Sandra whilst he was married. It stated that it is not true that he threatened Sandra, that he threatened the petitioner over Sandra Bishop. He confirmed that the petitioner made money available for the land. And he further confirmed that the document for 1.5 acres is complete while the other 1 acre is still processing. The respondent stated that he is ready to release the documents to the petitioner. He confirmed that the petitioner was pregnant and lost the pregnancy and stated that he did not neglect the petitioner. The respondent stated that he did not tell the petitioner that he was unhappy and wanted a divorce. The respondent stated that he was not married before. He married the petitioner and that the marriage certificate reads divorcee. He further stated that he did not mislead them at the registry. The petitioner relies on desertion and unreasonable behavior, which is not reasonably expected to live with, as constituting facts for dissolution of the marriage, pursuant to 15(2)(c) and D of the Act, whilst the respondent petitioner also relies on 15(2)(c) and cruelty. From the written addresses filed by the parties, the following issues are distilled: whether the petitioner or cross-petitioner is entitled to dissolution of the marriage on the ground and fact related, and other ancillary reliefs for the release of the petitioner's land documents in possession of the respondent cross-petitioner. The respondent cross-petitioner's counsel's argument is that parties had lived apart for more than 2 years before the presentation of the petition, and there is no objection to dissolution of marriage. However, none of the parties applied for dissolution of the marriage on the fact of living apart for 2 years. That is under section 15(2)(e) of the Act. It is therefore too late in the day to raise such arguments at the address date where this was not pleaded and evidence was not laid in this instance. I shall therefore go on to examine the evidence of the parties in respect of unreasonable conduct, which the other party is not reasonably expected to live with, and desertion. Desertion has been defined as the separation of one spouse from the other, with an intention on the part of the deserting spouse of permanently bringing cohabitation to an end without reasonable cause and without the consent of the other. Anioke and Anioke, Uboto and Uboto, Nwanko and Nwanko cited, a Nigerian family law, but it's sadly also cited. And I'm quoting from the case of Ajetumobi, Oluwadamilola and Ajetumobi. Desertion usually involves one spouse leaving the matrimonial group or relationship without the consent of the other. The absence is typically prolonged and not justified by any legitimate reason. The fundamental aspect of desertion is that the guilty spouse has the intention of remaining permanently separated from the other spouse without the consent of the abandoned spouse. The 4 essential elements of desertion are, which must be pleaded and proved, are physical or de facto separation. And there are 2 types of desertion, simple and constructive. Simple occurs where the deserting party abandons the matrimonial home, while in constructive desertion, the spouse remains in the home but has abdicated all matrimonial responsibilities and thus by his or her conduct expel the other. This is de facto separation. The manifest intention to remain permanently separated. The spouse who leaves must have the intention to end the marital relationship. This is a deliberate and willful decision. I have cited the case of Olanrewaju Adesoji and Oluwadamilola Ajetumobi. In the case of Ogunjobi and Ogunjobi, the Court of Appeal held that this court, while considering the issue of desertion held by Ojodu JCA, that to constitute desertion, therefore, the petitioner must plead and lead credible evidence to prove the following facts: defects of physical separation, manifest intention to remain permanently separated, lack of just cause for withdrawal from cohabitation, and absence of consent of the deserted spouse. A defect of physical separation does not necessarily mean living apart from each other. In that respect, desertion remains a matter of fact and law to be determined by the courts hearing the matter. physical movement from the matrimonial home by the respondent is not a precondition for constructive desertion. See the case of Zacchaeus and Zacchaeus, citation provided. In the instant case, the parties were apart most of the time due to their circumstances. The respondent resides in Nigeria while the petitioner resides in the United States. The petitioner had put in work and time to come over to Nigeria to visit and even conceive, and was preparing to sponsor the respondent abroad. However, it would seem that obligations were not met on one side, and the respondent did not provide the emotional support needed to foster a lasting relationships when their unborn child was diagnosed to have Down syndrome. I believe the evidence of the petitioner that the respondent requested for a divorce in November or December 2023. Even if the respondent abandoned the petitioner in December 2023, the petition was filed on the 9th of October 2024, which is not up to a year of desertion. However, the petition was amended by a subsequent petition, which is dated 21st of February 2025. The law is that the amended petition supersedes the original petition, and the original court process now amended is discarded. Amendment relates back to the date of the document, and what stood before the court is no longer material to the court and does not define the issues to be tried. See the case of Obao Engineering and Almosel Nigeria Limited. It's a 2022 case, citation provided, and it's a Supreme Court case. In other words, the period of desertion or abandonment for 1 year from December 2023 till 21st of February 2025, when the petition was amended, is sustained. The petitioner therefore succeeds on the basis of desertion pursuant to 15(2)(d) of the Act. The narration of the petitioner that she arrived and had been picked up at the airport by the respondent who had listened in on family conversation of their concern for her to be married, and thereafter decided to take advantage of that information. But the fact of the marriage is not a problem for the treatment thereafter. The petitioner lived abroad and invested time to come to Nigeria to make the relationship work. She came to Nigeria to conceive. She assisted the respondent financially to get a car for car business, but rather than use it for business, was driving it as a personal car. It seems the respondent benefited more financially, despite the turbulence on the map of the marriage. The petitioner tried to make things work. She took time out to return to Nigeria, as I said earlier, to conceive. And when the baby was diagnosed with Down syndrome, the respondent did not offer the support needed to the petitioner. The petitioner had to make the painful decision of terminating the pregnancy without any support from the respondent, who had gotten tired of the relationship and said he wanted a divorce. I also do not think the respondent provided satisfactory response to the allegation that he was on Facebook contacting yet another foreign woman, one Miss Sandra. And when she asked him, he threatened her and said she was only assisting the lady to get a visa. He admitted that one Sandra Bishop is his Facebook friend, but denied having a relationship with her. These are worrisome signs of a partner who lacks commitment and has ulterior motives. The respondent admitted that he had assisted the petitioner to purchase 2.5 acres of land, and that the first purchase was 1.5 acres, which had already been processed and is in possession of the papers, while 1 acre is still under processing. He insisted there was no prior demand for the document, and he gave the documents to unknown. He couldn't give the documents to unknown evidence, to unknown persons. Sorry. The evidence of the respondent cross petitioner is that the petitioner started speaking to her with disrespect when she started processing his papers for residence in the United States. The petitioner relies on 15(2)(c) and (e) of the Act. See the case of Nwako and Nwako in respect of 15(2)(c), where the court held that for a petitioner to satisfy the requirements of 15(2)(c) must establish 2 essential elements. That since the marriage, the respondent has behaved in a way, and on the basis of those 2 facts, the petitioner cannot be reasonably expected to live with the respondent. Behavior within the context of 15(2)(c) may be an action or conduct by the respondent which affects the petitioner. It may be acts or omissions or course of conduct which must have reference to the marriage. Therefore, in the determination of what constitutes behavior, which the petitioner cannot reasonably be expected to live with, the respondent shall have regard to the duties and obligations of married life, which involves the duty of accepting and sharing burdens that may arise due to mental and or physical ill health of the spouse. The capacity of the petitioner to withstand stress imposed by the behavior of the respondent, the steps taken by the petitioner to cope with it, and the length of time the petitioner has been called to bear it, and the actual or potential effect on his or her health. In the quote, the standard of proof in such proceedings then is settled by section 821 and 2, which I have reproduced in the body of the judgment, and that's to the reasonable satisfaction of the court. And although the act does not define reasonable satisfaction, the test to be employed is objective and not a subjective one. That is to say, the conduct of a respondent that the petitioner would not be reasonably expected to put up with must be grave and weighty in nature as to make further cohabitation virtually impossible. The court will consider the totality of the matrimonial history of the parties to the petition. See Ibrahim and Ibrahim, Mwako and Mwako already cited, Olabiwonu and Olabiwonu. Relevant aspects of the matrimonial history should tell a continuing story of intolerable conduct on the part of the respondent to the petition. So the case of Adesoji and Adetumobi also cited earlier. In Nigeria, a court cannot dissolve a marriage or declare a marriage to have broken down unless one or more of the facts stipulated in 15(2) is established, even if the marriage appears to have broken down irretrievably. And I have cited the unquoted case of Ojodu and Oko. Unreported WD 21 Lagos High Court delivered on the 10th of March, Jamalu and Jamalu, in respect of the provisions of 15(2)C, as stated above. It is pertinent that what sort of behavior of the respondent should the petitioner not be reasonably expected to put up? See cars and cars. Behavior is something more than a state of affairs, or more than a repugnance to sexual intercourse, or a feeling that the wife is not reciprocating his love or not demonstrative as he thinks she should be. Behavior in this context is an action or conduct by one party which affects the other. Such conduct may either take the form of acts or omission, or may be the cause of conduct. And in my view, it must have some reference to the marriage. In other words, the conduct of the respondent that the petitioner is not reasonably expected to put up with must be grave and weighty in nature as to make further cohabitation virtually impossible. However, before the court will come to that conclusion, the entire history of the marriage has to be considered. In other words, the court must consider the totality of the matrimonial history of the parties in the petition. Ibrahim and Ibrahim petition provided. The history of the marriage reveals lack of commitment and empathy by the respondent. The marriage seems to have been built on faulty foundation and expectation of moving upward, and when this was not met, but rather challenges relating to the burden and possibility of a child born with some form of disability, this made the respondent disinterested in sharing the burdens and obligations of the marriage. The conduct of the respondent must be grave and weighty in nature as to make further cohabitation impossible, and the court will come to the decision as to whether any right-thinking person will come to that conclusion that the respondent has behaved in such a way. The court will have to look at the whole circumstances of the marriage, the characters and personalities, in order to establish intolerable conduct. The respondent pleaded an alleged cruelty and intolerable conduct pursuant to 15(2)C as well, but merely stated in evidence that the behavior of the petitioner changed and she started speaking to him with disrespect. I do not think the respondent cross-petitioner has established facts that are sufficient enough to uphold the fact of a reasonable conduct. If the respondent is unable to be expected to reasonably tolerate or live with, the fact is not proven to the reasonable satisfaction of the court. However, considering the entire matrimonial history, the steps taken by the petitioner to make the marriage work, the mental, emotional, and financial inputs in the marriage, and the unwillingness of the responsibility of the respondent to share the burdens and obligations when challenges came, it is unreasonable to expect the petitioner to continue to bear the burden alone. I therefore accept that the refusal to share the burdens and obligations of the marriage is grave and weighty enough to establish unreasonable conduct under 15(2)C. I accept the evidence that by the that the respondent said the petitioner should keep the pregnancy and his not interested in the marriage and wants a divorce. The ground of abandonment or dissolution of marriage and intolerable behavior is accepted as established by the petitioner, and the court shall grant a decree of dissolution pursuant to those terms. On the issue of the land purchase on behalf of the petitioner by the respondent, the petitioner pleaded that 3.5 acres of land were purchased for her by the respondents. During examination in chief, the petitioner mentioned 24 plots of land. The respondent, on the other hand, insists that only 2.5 acres of land or 20 plots of land calculated as 8 plots per acre. The petitioner did not tender any further evidence in portal. The testimony of the respondent is accepted, since parties are not at idem as to the computation of plots and acres, and the petitioner has not put forward any proof. The admission of the respondent that 20 plots of land or 2.5 acres of land were purchased in trust for the petitioner is accepted by the court. Whatsoever is admitted need no further proof to establish same. See the case of Ogochi and Ode, citation provided. From the foregoing, I hold that the petitioner has proved desertion and unreasonable conduct which the petitioner is not reasonably expected to live with by the respondent cross petitioner to the reasonable satisfaction of the court. Now, I hold that follows. A decree NISA is granted dissolving the marriage between the parties, which marriage process that the federal marriage registry for Lagos State and the ground that the marriage has broken damage irretrievably. The decree NISA shall become absolute 3 months from today. If there is no contrary order of this court, the court orders the respondent to release to the petitioner all the original diary documents over the land, parcel of land measuring 2.5 acres of land, situated and lying at Bala of Enere Bala Road, behind government secondary school, Bala, in the Asa local government area of Kwara State. The landed property of the petitioner, which the respondent held the original title document in trust for the petitioner. That is the judgment of the
I wonder if somebody what you can say. So the case of plants, cause always not no things.
right.
What's this in my note for you? Sorry.
Right. I understand.